Hey everyone, welcome to another episode of Re-Federalist Radio, hosted by Zachy Radio, where we take a look at current events through an original intent of the Constitution lens. I am Brady, also known as Warhamster, and joining me as usual, my good friend, constitutional mentor, Mr. Constitution himself, Douglas V. Gibbs.
And always, thanks for having me.
Yeah, long time no talk. We just got done a really fun show going through Madison's notes, and the star today was our favorite anti-hero, Alexander Hamilton. So you're going to want to check that out later.
And I want to say something real quick, and this is off topic. It's real quick because, see, I have this love of sports, and I get ragged all the time, and I love also dealing it out. So I only have 4 words for Warhamster. How about those Indiana Hoosiers?
Well, that one hurts. All right, that one hurts.
Now, I've got my friend Ron. He and I are the Dodgers. God, I hope the Mariners do well. But anyway, go ahead.
We're not doing sports talk today. Because, that wouldn't be fair to Doug because he is a lifelong Angels fan. And anyways, we digress.
It's a long drought with one World Series in the middle.
Go Padres. Never mind. All right, before we get in, let's thank everyone listening on America Matters Radio, 93.7 KPGF, AM 1060, and all of you listening on the affiliate networks and stations, especially ZachyRadio.com. All right, we got a very important topic today. The Supreme Court, as we're sitting here right now, are hearing live arguments in a case that's going to decide a racial redistricting. Could I buy a vowel today? Jeez, what is going on?
It's all those long words that Hamilton uses still got you messed up.
No, I feel like I just went to the dentist or something. I'm waiting for the Novocaine to wear off. Anyway, the case is kind of a big deal. We're going to spend.
And this ties into the Voting Rights Act, which, from a constitutional viewpoint, was unconstitutional in the first place. But we'll get to the details of that. Go ahead.
Yeah, we're absolutely. I'm going to go ahead and share my screen, and we're just going to read a really good summary of it. Okay. This is an article on SCOTUS blog, a wonderful resource written by Amy Howell on October 10th. And she says, the Supreme Court will hear oral arguments on Wednesday, October 15th in Louisiana versus Callais. I think that's pronounced like that. A challenge to the Congressional map that Louisiana adopted in 2024 that may reshape the Voting Rights Act, as Doug said. It is the second go-round at the court for this dispute in less than a year. The justices heard arguments in the case for the first time in March, but didn't decide it during the 24-25 term. And here's a brief explainer on the long, complicated history. So we'll talk to you about the 3 real big governing documents here that they're going to be referring to are, of course, the 14th Amendment, the 15th Amendment, and the 1965 Voter Rights Act. And we'll go through those in detail as we go. But let's jump into the background. The dispute begins in 2022. Louisiana passed a 1-majority black district out of the 6 seats in the state, although roughly a third of the state's population is black. So, of course, a group of black voters went to federal court, and they argued that it violated the Voting Rights Act, which prohibits election practices that result in a denial or abridgment of the right to vote based on race.
And there's another step there also in the Voting Rights Act, which it requires any time that a state makes changes, and more specifically southern states, make any changes to their voting laws, they have to get congressional permission first.
Yeah, let's hear some background. What was the reason the Voting Rights Act was passed in 1965 is a lot of southern states were discriminating against black people by gerrymandering their districts and doing other things to try to suppress the vote.
This is on the heels of the 24th Amendment, which got rid of a poll tax.
Yeah, so this was a real problem they were addressing. The problem, which we'll see, is they created a reverse racism type situation. And that's what they're struggling with here, 30,000-foot view.
They're playing a game that's similar to what some of you might know as affirmative action. We have to make a group equal by giving them a boost up. But if you read the language of the 14th Amendment, that's not what it says. Equal protection under the law.
Which we will be doing. And they're going to make these arguments based on race, but this is absolutely politicized. This is a Democrat Republican. How do you get more voters? And to try to pretend
Absolutely, it is.
And I was listening to some of the oral arguments, and that was one of the first things that Clarence Thomas asked one of the attorneys that was on the side of the black voters who filed the suit. So this is a lot of it's going to talk about race, but remember, this is all politicized.
And I want to for the viewers / listeners, if you have a pocket constitution, what we're going to discuss eventually here too is Article 1, Section 4. So definitely open your constitution to that. All right, go ahead.
All right, in 2024, the Louisiana legislature drew a new map. Okay, so I'm sorry, I missed the part. So the federal court agreed with the black voters that the 2022 map violated Section 2, barred the state from using their new map for future congressional elections, and redirected the state to draw a new plan. The U.S. Court of Appeals of the Fifth Circuit upheld that ruling. So they go back to the drawing board and submit a new map for 2024 known as SB 8. SB 8 is what is being disputed here. And this created a second majority black district. The terminology here is majority minority. The practice has been pretty much since '65 to create a lot of districts, even though they may be shaped like a salamander. Just they just want to have, so you get 60% of the voters of a certain color or language that they speak or what have you. The problem with that is if you have 60% of people in district that are black, and you have 40% that are white, and it shows predominantly that in America right now, people vote for party lines almost among race, although fortunately that's changing a lot because people don't all think alike just because they have the same skin color. We do have different
and there are certain groups such as Hispanics and blacks that are actually taking a position that because they're realizing, oh, wait a second, they take advantage of us. They're taking us for granted. So they're not appreciating that position. They're realizing that just because grandma was Democrat, just because dad was Democrat, doesn't mean I have to be Democrat, or vice versa.
All right, I think that should take us to the break, and we'll continue on the other side. On SCOTUS blog, it says a different group of voters who describes themselves as non-African American contended that the 2024 map was unconstitutional racial gerrymander. That is impermissibly sorted voters based primarily on their race in violation of the Equal Protection Clause of the 14th Amendment. A 3-judge district court agreed with them and barred the state from using the map in congressional elections. So what we have here is one group taking an interpretation of the Voting Rights Act and the other group taking their interpretation of the 14th Amendment. In such a case, Doug, does an act like the Voter Rights Act supersede the Constitution?
Well, no, and also there's two things going on here. It's not just whether or not it is in line with the 14th Amendment, and also whether or not it's in line with Article 1, Section 4, which says the times, places, and manner of holding elections for senators and representatives shall be prescribed in each state by the legislature there, but the Congress may at any time by law make or alter such regulations except as the places of choosing senators. In other words, Congress can make a law to alter regulations that they believe a state is using that may be tyrannical or outside the Constitution or the law. It does not say that they can make a law ahead of time about it. In other words, the Voting Rights Act is a law made saying, hey, you better not do this or we got you. That's not how this is worded. It's worded that state makes a law and the Congress goes, whoa, that's a little off. We need to make a law negating that.
Yeah,
so the very existence of the Voting Rights Act, aside from the 14th Amendment, including Article 1, Section 4, is unconstitutional.
And I'll just read Article 1, Section 4 real quick. I have it right here.
I just read it. Oh, are you talking about the Constitution? I just read it.
Oh, you did it verbatim?
Yeah.
Okay. I was still looking for it on my screen, so I kind of tuned in. All right.
I got you, man. I got you.
I appreciate that.
And when it comes, and here's the thing, getting back to the Equal Protection Clause, it does not say you make laws so that it's equality of result. It's equal equal protection under the law. In other words, the law will be applied exactly the same across the board.
Yeah, it's just, reverse discrimination is still discrimination.
Mm-hmm.
All right, continuing. Supreme Court put the 3-judge district court's decision on hold in May of 2024, allowing the state to use the 2024 map in that year's elections. Voters in the newly drawn district elected Cleo Fields, who had represented a majority black district in Congress for 2 terms during the 90s until the districts were redrawn. Louisiana and the black voters, who had challenged the 2022 map, appealed the 3-judge district court's decision to the Supreme Court, which in last November set the case for oral argument. The dispute initially focused on the 2024 map itself, specifically whether the lower court was correct when it concluded that the second majority black district was an unconstitutional racial gerrymander. Okay. And again, both parties have done gerrymandering throughout history. It is a problem, but there's mathematical solutions. There's a effort at a group called, what are they called? I got that around here somewhere. How'd I lose it? Okay. Based out of Princeton, I believe, that's, all for doing mathematical analysis of how gerrymandering should be done. And it's an incredibly left-leaning analysis. There's also groups that are equally doing the same from the right. The bottom line is, if the left side, the Democrats have done a better job of gerrymandering over the years than the Republicans have. That's starting to swing as we see some of these red states grab a couple extra districts. Texas just grabbed 5 more districts.
And let's understand, in Texas, that's not gerrymandering by the Republicans. It's undoing the gerrymandering that was in place by the Democrats, making the districts more of a reasonable shape rather than these arms sticking out in all directions to try to going back to the whole point of gerrymandering. When Elbridge Gerry was governor, and there was and he approved a redistricting for the state Senate. This is before all of the states were doing one per county, and and a newspaper reporter looked at it and says, well, it looks like a salamander. And that's where the word gerrymander comes from, where you have these arms going out in all directions, these tendrils trying to influence the vote. And that's what it is. It's an influence of the vote.
And what they're trying in California right now, the Oceanside, which is near and dear to both Doug and my heart, currently has its own congressional district for the most part. Now they're going to draw the map so Oceanside split in half, when part of Oceanside is actually leaps over the rest of North County and joins a district which includes Palm Springs, which, if you know California, that is ridiculous.
One of the things they did to put all the Republicans into one district a couple elections ago is they put the area just north of Camp Pendleton, all those cities right there in the same district with Temecula. They're on the other side of the mountain from each other. But what it did is it went from 2 Republican districts to 1.
Yeah, that's really a strategy right there. That's how they do it. And it's dirty, but there's this ruling right here may change that quite a bit. At stake here, somewhere around 20 to 5 or more seats that could be redistricted before the 2026 primaries.
And that's why these elections are so important. And you Californians, if this bothers you, if this angers you, I mean, there's a candidate for governor out there right now, Leo Zaki, leozaki.com, which is, on our side with this. He's like, wait a second, this isn't right. So definitely do your research on your candidates.
Yeah, and Leo is also a good friend and kind enough to be the sponsor of our radio show. So another reason to like Leo. All right, jumping back.
And I'm asking the audience, regardless of whether or not he's behind this show or anyone, do your research. Go to all of because there's the front runners, and the names. You got the Chad Bianco, you got the Steve Hilton. Don't forget to check out people like Leo Zaki. Make your comparisons. Because I believe that a candidate like Leo Zaki could turn the whole state on its head if he was to get into the governorship. leozaki.com.
Very good. Continuing on. Louisiana and the black voters defended the 2024 map. Louisiana contended. So Louisiana, okay, let's see what they said. Louisiana is now on the side of supporting their new map, not the one that was 5-1, the one that's 4-2. They contended it was caught between the proverbial rock and a hard place. In the challenge by the black voters, it argued the district court had concluded that the 2022 map, with only one majority black district, likely violated Section 2 of the Voting Rights Act. The state therefore opted to draw a new map with a second majority black district to comply with the district court's ruling. But once it made that decision, the state said, its focus shifted to drawing a map that would protect some of the state's powerful Republican incumbents, including Speaker of the House Mike Johnson and Rep. Julia Letlow, who sits on the House Appropriations Committee. So they're basically making two defenses here. Yeah, we complied with the court's ruling, but now our new map isn't based on race-based. It's based on we did it for political purposes, which is an admission of dirty politics, but they're using that as their argument, that it wasn't racial in 2024. The black voters echoed the state's argument because the state says that politics, rather than race, was the focus of its redistricting decisions, what I just said. They contended the Supreme Court's cases require the non-African American voters to meet the high bar of showing that race was the primary factor in the legislature's decision to enact the map, a showing that they said the challengers cannot make. This is what I just said. They're trying to say that you cannot argue that the new map is racist.
Or that any of the ways that they've been doing it has to do with race if it doesn't fit the left-wing narrative. You can't prove, well, they did it for that reason.
It's interesting that the state of Louisiana, has taken that position. The non-African American voters told the justices that as the three-judge district court concluded, it was, in quotes, utterly implausible that race and politics played equal roles in the drawing of the 2024 map. The legislature decided first to draw the second majority black district, they said. It was only after that decision had been made, they argued that the Republicans then had to choose which Republican to sacrifice. And to the extent that the state's focus was to comply with the Voting Rights Act, they continued that just shows that race was the legislature's main motivation when it drew the second majority black district. That's a pretty strong argument, I would think.
Yes, it is.
Yeah.
And once again, the equal protection under the law is not equity in result. It's equity in opportunity, and it's equity under the law. Remember, when you look at that statue of Lady Justice, right? She's got the scale in one hand and the sword in the other, but what's over her eyes? Blindfold. She's supposed to be blind to all of these things. The law is supposed to be blind to everything except for the law. The Constitution is the law of the land. And, man, once again, we have laws being made that are not based on equal protection, but on a seeking of equity in results.
So here's where it gets really interesting. I'm going to get this next paragraph, and then we'll jump to Clarence Thomas's dissent after the break, because we've got about another 90 seconds to go. There's no way to know exactly why the justices opted to schedule the case for another argument. The brief order that the court issued on June 27th, which Doug and I covered, which was the last term's final day before the justices' summer recess, simply indicated, without any explanation, that the dispute was restored to the calendar for re-argument, and that in due course, the court would issue a follow-up order on scheduling, and any additional questions to be addressed in the supplemental briefing. That's interesting, because that leads me to believe that enough justices thought that the case hadn't been argued properly the first time. We want to hear this again. Mm-hmm. We're going to hear this again. Here's what we want you to be arguing, which they would tell us more later on as we go along in this story. Let's see. We've got about 30 seconds before the break. I don't want to jump into Clarence Thomas's comment at this point. I want to give that its full justice. I don't want to race through it, but it's pretty much when I'm reading this article, it's exactly what I was thinking. Again, there's a number of things that, if they go the right direction, Republicans can get pretty close to a supermajority in the House of Representatives, no matter what happens in elections. It's just by the redistricting if it's done correctly. Anyway, we'll talk about that when we get back from the break. All right, we're getting ready to get into a dissent from Clarence Thomas. I wanted to give it full justice. I'm going to go, when this show is over, I'll be listening to the 2 or 3 hours of oral arguments. I only got about 30 minutes in before the show. But what I'm going to be listening for are the questions from Justice Roberts and Kavanaugh. Those are going to be the swing votes in this. And the nature of their questioning will tell us how this is going to go. We're not going to get a decision. Hopefully we're going to get one by the end of December. And that would give legislatures enough time to get there before the 2026 primaries to do anything that needed to be done. So this should be done relatively quickly, but nobody's given us a firm indication. All right, so Justice Clarence Thomas dissented from the decision to hear re-argument in the case. In his view, there's an intractable conflict between Section 2 of the Voting Rights Act and the Equal Protection Clause of the 14th Amendment of the Constitution. To the extent that the Supreme Court's interpretation of the VRA violates the 14th Amendment, he wrote he would make clear that the Constitution controls.
And understand, this is a man who, in the 2019 Garland versus United States case, said if there is a ruling or an opinion by the Supreme Court or any federal court that's egregiously unconstitutional, it needs to be changed. It needs to be flipped. So what he's saying is just because the court said something in the past doesn't mean it stands.
Yeah, and there's been a number of cases throughout the 60s, 70s, and 80s, and even more recent, that have sort of addressed this issue, and they have always fallen on the side of the reverse discrimination redistricting. We're seeing that shift in a lot of this Supreme Court's recent decisions of the last couple of years as they've moved more and more closer to the right direction of federalism and original intent, and with Justice Thomas leading the way. All right, so into more detail. We've talked about this a bit already, but let's listen to their words. On August 1st, the Supreme Court issued an order instructing the litigants to file new briefs addressing, this is over the summer, this is what they want them to talk about when they re-argue, whether the state's intentional creation of a second majority-minority district violates either the 14th Amendment, which bars the government from treating similarly situated people differently, or the 15th Amendment, which prohibits the government from denying or restricting voting rights based on race. Now, Doug, I was surprised they brought the 15th Amendment in here because we're not restricting or denying voting rights with these gerrymandering.
Right.
So I'll be interested to hear that argument. But the Supreme Court wanted to hear an argument on the 15th Amendment. Maybe that came from one of the liberal judges to try to give them another out. I don't know. That's my guess. In a brief filed on August 27th, Louisiana no longer defended the 2024 map. It told the justices that race-based redistricting, even if done to comply with Section 2, is unconstitutional. Quoting the Supreme Court's 2023 decision in Students for Fair Admissions versus President and Fellows of Harvard College, which struck down the use of race in admissions at colleges and universities, the state declared that eliminating racial discrimination means eliminating all of it. That's a bit of a flip-flop by Louisiana, would you not admit?
No, absolutely. And understand, and Louisiana is basically, I think, saying this in a sense, that the Equal Protection Clause is designed to protect individuals, not groups. When you use a affirmative action style idea, you unfairly penalize individuals by giving preference to other groups based on their race, rather than merit or qualifications or the basic regions when it comes to redistricting. And so, and I think some of their argument is recognizing this.
Yeah, very much so. And again, you and I applauded that the Harvard admission case 2 years ago, and it was argued properly.
Right.
Okay, continuing. The 14th Amendment, the state contended, commands that the government may never use race as a stereotype or a negative. Wouldn't that be nice?
Yeah, once again, that goes back to what I was saying earlier. The Equal Protection Clause is designed to protect individuals, not groups.
Very well. Said, yet race-based redistricting rests on an invidious stereotype that all minorities, by virtue of their membership in their racial class, think alike and share the same interests and voting preferences. Similar to what we said earlier.
Yeah, good argument. Once again, this argument once again is focusing again on being individuals, not members of a group. Just because you're a member of a group doesn't mean you think a certain way, and if anything, that would be more racist than the claim the otherwise.
Wouldn't you have liked to have been a fly on the wall when the decision was made in the Louisiana State House to, well, we went from defending SB 8 to now we're opposing SB 8 over the course of the summer?
One wonders who the loud voices were, who brought some sense, and who went, okay.
Yeah, it would have been a fun one. All right, the black voters continued to defend the 2024 map, which, according to them, comports with the 14th and 15th Amendment guarantees of equal voting rights and the VRA's requirements. They argued that Section 2 is, in quotes, the crown jewel of civil rights legislation and falls within the heart of Congress's authority to enforce the Constitution.
Now, this idea of equal voting rights, understand what the Constitution says. What it says is that Congress shall make no law that creates an unequal environment. Not that government must make law to lift up a particular group. And so equal voting rights is all about restricting government from making law, not encouraging more law in the attempt to get a certain result.
Yeah, and that's really fundamental to some of the ideological differences between what we represent, which is, original intent of the Constitution. And, you'll talk to a liberal and they'll say, well, it's the right thing to do because blacks were persecuted all these years. And again, you do not address past discrimination with future discrimination. And that's what's been going on. And a lot of this stuff came out of the civil rights era of the 60s, and they went too far. And some of that's starting to get pulled back.
Yeah, and this is not to argue that there were no historical wrongs, or that there haven't been or still isn't different discriminations. We recognize that in part of human nature, but the way, as you've said a number of times, the way to fix discrimination on one side is not to then resort to an opposite extreme where another group gets discriminated against in the process.
Yeah, just interesting, before we go too far, the Harvard ruling was correct, yet they've continued to do other forms of affirmative action. They're trying to find ways of continuing what they were doing, and there will be a showdown with the Trump administration over that.
Right, and that Harvard case, what it did is it brought to the surface that there are actions, there are policies that unfairly penalize Asian and white applicants, giving preference to others. This was affirmative action on steroids, in a sense. Again, you don't fix one wrong by creating another wrong.
Agreed. College admissions should be based on merit.
Period.
Not immutable characteristics.
And of course, the argument is, well, how can they reach that merit if their schools are, a lesser school? That as individuals, then we need to see what we can do about getting our kids into the best institutions, whatever. That's what we do as individuals. I've always been one that argues there's no excuses. Everybody's capable. Ben Carson's a great example. One of my favorite examples when it comes to that anybody is capable of breaking out of whatever tough situation you start in is Nick Vujicic, which is this Australian pastor born with no arms, no legs. The guy goes swimming. He's a big-time public speaker and so on and so forth. No excuses.
Yeah, and it's fair to we're addressing the education system by kind of dismantling the Department of Education. So hopefully that helps with some of the school comparisons, because Department of Education all of our education has gone downhill ever since it was created. Yeah, well, in an attempt to be fair and progressive, you've destroyed the entire thing. It's the old saying, right? You throw the baby out with bathwater. Yeah. Well, it's what is it? You hold back the more gifted students by catering to the lowest common denominator in education. And what you're going to wind up getting is the lowest common denominator. Yep. Section 2, they wrote, authorizes some consideration of race in redistricting. Doesn't say that, does it? No. But only when doing so is required to remedy identified racial discrimination. So they say if we can identify racial discrimination, we have to do something to fix it. That's their argument. If Section 2 is not available to protect black voters in Louisiana, they cautioned, it will not end discrimination there or lead to a race-blind society, but it may well lead to severe decrease in minority representation at all levels of government in many parts of the country. Okay, now, of course, it could be argued that we currently probably may have over-representation, but again, we don't want to.
And you have a little bit of a double standard here, of course. We want a race-blind society, yet we're going to have Black History Month, Hispanic History Month, and so on and so forth. And I grew up in North Long Beach, of one of the places I grew up in the just south of Los Angeles. And one of the things that I've always told people is I'm not racially blind. I know if a person who is not the same skin color as me is coming towards me. The thing is, that's not a factor in my decisions. It comes down to my individual interactions with them. Now, obviously, if someone's going to act a certain way, dress a certain way, we do form opinions. That's what we do as human beings. And that's up to us individually to address that. The question here isn't whether or not humans do that and if government has to help fix it. The question is, can government make laws regarding that? And ultimately, no, that's up to us. That's up to our culture. That's on us. Congress can make no law creating anything that goes outside the equal protection under the laws.
Continuing, the non-African American voters argued Section 2 was inconsistent with the letter and spirit of the Constitution. We agree with that. Mm-hmm. The provision, they contended, does not eliminate hard-to-reach discrimination, as its supporters assert, but instead is now discrimination's main source and aggravator, by requiring race-based redistricting, which violates our colorblind Constitution. But even if Section 2 could apply in the abstract without running afoul of the Constitution, they continue it still violates the Constitution here. The black voters have not shown the persistent intentional racial discrimination in redistricting justifies the VRA's race-based sorting and balkanization of voters into mandated quota districts. And I love that sentence. Let's see, we got about 30 seconds before the break. Do you want to give yourself a quick plug, or do you want to give Mr. Zaki a plug?
Well, yeah, matter of fact, I had that in my mind. You're reading my mind. So as we get ready to go into our final break of the program, be reminded there are important elections coming up, and one of them is for governor in California. So those of you in California who are listening to this program, Leo Zaki for governor, leozaki.com. As for myself, DouglasVGibbs.com, navigation, 2, liberty.com, navigationtoliberty.com.
I guess we can break on that. All righty. We'll welcome ourselves back. We're making perfect pace, and I think we're able to finish this with a few minutes to spare for some general discussion. So good job, Doug. Good pace. The Trump administration filed a brief in which it urged the justices to uphold the 3-judge district court's decision. U.S. Solicitor